The Crossman decision, a controversy in the South Carolina Senate about does an insurance policy mean what it was represented to you when you bought it, or does it mean now something different that the court has construed it to be, and was the contract even subject to interpretation when it went to court? These were questions that the Senate dealt with on the Crossman decision. In a nutshell, here's what was at issue. Since 1966, an insurance policy, general liability for contractors, they also covered subcontractors, was that the policy covered an occurrence. An occurrence was also repeated exposure to a harmful condition. The court came along and said it can be that, but only if a fortuitous circumstances occurred between the time of the negligence and the exposure over the long period. So the question became, what in the world was the insurance sold for if it didn't go cover the negligent act and it didn't go cover the damage that results? How does that affect you, the average person? You got a home. A subcontractor's been hired. Contractor didn't know the work was defective. Your home's been leaking for several years. You got tens of thousands of dollars worth of damage. You go back to the contractor, want it fixed. The contractor doesn't have the money, but he's got the insurance, or he thought he had the insurance, but now he doesn't. And the application of this decision would go 8 years forward. So for you, the consumer, and the people of South Carolina, it was important to make sure coverage was there. I was active. I put in a bill to put the law back where it was when the parties bargained for the coverage. And what they bargained for was general liability coverage. It protects the contractors, the subcontractors, and you, the consumer. Otherwise, all of that money would have ended up going out of state, probably, some of it in state, in big profits, because they didn't have to cover what they initially said they were going to cover, because the law got changed by the court. That's important here in South Carolina. Laws need to be made in the General Assembly, not in the courts. And so I think when the General Assembly has the opportunity to speak, it should speak, and particularly to protect you, the general public.